Okay guys, this video is to go along with the Module 3 dealing with the legal environment of public sector labor relations. As I mentioned in a previous video, the genesis of labor relations in the public sector and the private sector are very, very different. And they occurred at different times and in different fashions. Now this chapter goes through the development of labor relations at the federal level, and then it looks at what happened at the state and local level. And it's important to understand this in a political context. In 1919, there was a Boston police strike, and the Supreme Court ruled that a government employee, particularly a police officer, had no right anywhere at any time to strike against the public interest, the welfare of all. And that was pretty much the prevailing attitude about public employee unions. But as I said, these unions grew out of associations rather than labor unions in the sense of industrial labor unions. And they did start to emerge. And they emerged as political players. And the initial legislation dealing with this topic at the federal level emerged during the Kennedy administration. The textbook is kind of bland about what actually happened here, but Kennedy, as you know, a Democrat, was responsive to the demands of the labor movement in general. And one of the things the labor movement wanted was a movement on the rights of federal government employees. Kennedy, in response to support from the AFL-CIO, issued an executive order. You may have heard of these today. They're very controversial. Today they're always controversial, but Kennedy issued an executive order granting certain organizational rights to public employees at the federal level. Very, very basic sort of stuff. You had a right to meet and confer to discuss the impact of possible changes and so forth. No right to be involved in serious collective bargaining. The Nixon administration subsequently issued a few more executive orders and clarifying what was meant. But it wasn't until 1978 that the first piece of legislation giving federal government employees certain sorts of rights, that is to form an organization and to essentially ask for things. Specifically excluded, of course, is the largest of the federal employee groups, the military. They're not allowed to be involved in the union. I know that will sound strange to you, the very idea of the military being involved in the union, but in other countries it's not that unusual. Anyway, the feds issued, the Nixon administration and subsequently the Gerald Ford administration issued executive orders, and as I said, eventually you had a passage of legislation that's codified the rights for federal public employees. And if you look at the text on the first parts of it, it looks at the Civil Service Reform Act of '68, and it gives you some idea of the basic coverage of that law. To the best of my knowledge, I don't think there are any federal employees in the class, so most of you will not be involved, not covered by or impacted by this law. And it's sort of interesting in a way, sort of an artifact of history rather than particularly relevant to what we're talking about today. What is more important is what happened at the state level, or what's happening at the state level in terms of legislation. You have states that have no statutes at all, and it's a violation of public policy, and I mentioned those to you before in Texas and South Carolina, maybe North Carolina as well. That doesn't mean that there's no collective bargaining within the state. It means that they turn a blind eye to strong police or firefighter unions. There are states at the opposite end that have comprehensive statutes covering all public employees under one general rubric. Then there are the much more common arrangements where there are states that have specific pieces of legislation dealing with specific groups of public employees. For example, in California, there's a law dealing with the state civil service employees. There's a law dealing with local government employees. There's a law dealing with K-12 teachers. There's a law dealing with university employees. And there's a law dealing with blue-collar workers that work for the state. That's a much more common form of operation. There are also some states that don't have laws but have practices that rely on the interpretation of their attorney general as to does the local government have the authority to negotiate, to sit down with an employee organization. And that's pretty unusual now. Most states have gone towards developing their own legislation. And finally, the issues that are covered by this legislation vary from state to state. Some states specify what the scope of bargaining is. Some states specify what the mediation process will be. Will there be mediation, fact-finding, and arbitration? Some states say there will definitely be no arbitration. And some states have an issue in terms of dealing with a strike. In, I think it's Montana, a public entity is allowed to go on strike, a healthcare facility is allowed to go on strike, for example, provided there is another one within 150 miles that's open. But the point I'm trying to get at here is there's a tremendous variation on the content, the scope of bargaining, what's permitted, what's not permitted. The mission of the agency, is, for example, is not permitted, even though the reality of collective bargaining for local government employees is that bargaining does impact the mission. For example, with police. In the old days, there used to be 2 people in patrol cars. It got rather expensive, and so the police agencies decided to go with 1-person patrol cars. Does that affect? Was that bargainable? Well, the police officers felt that it was a safety issue, and as such, it should be bargainable. Now that was sort of resolved, and these issues did work out. On the other issues of union security and unfair labor practices, again, there are a variety of different approaches to what constitutes union security. And that's going to be a topic of another video, because the union security issue is front and center today. Okay, guys, later.